welcome you on behalf of the sponsoring organizations displayed on the screen and the host law firms. And I'd like now to ask the chair of the Consumer Attorneys Association, Mike, could you come forward and, okay, welcome, just welcome people.
I can do it from here.
Great.
Hi, my name is Mike Harris. I'm actually the president of the Consumer Attorneys of Los Angeles, and I'm happy we were able to host this event. You guys are actually the first organization not part of CALA that we've been able to offer to outside organizations to have events such as this. This office just opened up in January, so while you're here, please walk around, see what we have, what we set up here. Just for those who don't know, CALA is the largest plaintiff-only trial lawyer association in the country, the largest local of any. And I want to thank you for attending. We worked with the Jury Project to make this happen for you guys, and we're happy we were able to do it here in our offices. So thank you, and it all turns out the way you're planning.
Thank you very much. So one of the keys to this program, I'm going to make a few introductory remarks and we'll ask the judges who have agreed to serve on the panel to come forward, and then I will ask them some hard questions, kind of reversing roles for a change in my career. I get to ask the judges questions rather than the other way around. In any event, the Civil Jury Project was established several years ago as the only academic center in the country which was asking the question, why are jury trials, indeed all trials, civil trials, disappearing? Whether we should be concerned about that, and if so, what can be done about it? I don't have to tell this audience, but you know that the right to trial by jury was so important to our founding fathers that it's mentioned not only in the Declaration of Independence, Article 3 of the Constitution, but in 3 of the Bill of Rights. It's the only right that is mentioned 5 times in our founding documents. Trial by, at the time the Bill of Rights, at the time the 7th Amendment was passed, the constitutions of every state that was in the Union guaranteed trial by jury in civil cases. Jury trial is so much part of the architecture of our justice system that there's not a courtroom in the country, or very few, that do not have jury boxes. Yet, sadly, those jury boxes are largely unused. This is a graph of the number of civil jury trials and bench trials per authorized federal judgeship for the last 55 years since 1962, and it shows that the number of jury trials has dropped from 10 on the average per average judgeship to last year it was 2. And you cannot help but noticing with this graph that bench trials have declined even quicker and more than jury trials. The decline of bench trials is probably my best evidence that the disappearance of jury trials is not due to some special characteristic of jury trials. Either their expense, or their length, or the fear of a runaway verdict, or the requirement of specialized jury advocacy experience. Slide 3 shows that last year, 2017, the average judge, federal judge in the Central District of California tried 3 civil jury trials and 2 bench trials. Now, while that sounds embarrassingly low, it's not compared to the other districts. The Central District of California ranks 17th and 5th in the country when it comes to jury trials and bench trials, respectively. 17th and 5th among the federal districts. One might explain the decline of jury trials by saying that, well, the number of cases being filed has dropped, and that's true. But the next slide accounts for that, and in turn it shows the result if you look at just the percentage of civil terminations by bench and jury trials, and clearly it's almost off the chart by the time you get to 2017. This slide and this slide shows a similar pattern for the Central District of California, that you're disposing of as a percentage less than 1% of all cases by jury trials. This is only for the last 17 years, not 55 years. So clearly the line is getting a little flat as it gets down to practically 0% of terminations. Let me mention briefly what the Civil Jury Project has accomplished in the last 3 years. We have created and maintained 2 websites. The first is and this is a chart here. I could not get the figures readily available for California state courts. This is relatively flat line from 2001, but I don't have a lot of confidence that it's a very low percentage. Again, almost under 0.2% of cases disposed of are resolved by jury trials. But when you get that low, I assume there's some. No one's suggesting the jury trials are going to disappear completely. It'll just be like the California condor, rarely seen, but still around. That's kind of the situation we have with jury trials. The first website we created is one for use by lawyers and academics and judges. And there's a lot of material on here that changes all the time. It lists our 260 now judicial advisors, state and federal, around the country. We have over 65 professors who are academic advisors, and we even have 35 jury consultants, some of whom are here today, who serve as jury consultant advisors to our projects. Our projects include engaging in empirical research, such as we made a survey of non-lawyers that demonstrated clearly that 80% of the people in this country who are not lawyers think that the number of trials in the past 10 years have increased. Totally contrary to what these statistics show. And of course that's a big problem because if people are not aware of the problem, they continue to believe that there is some kind of litigation explosion going on and that it's a good thing that there are fewer. It would be a good thing if there were fewer trials. We studied during a 6-month period of last year all contracts filed with 8Ks by public companies with the SEC. We wanted to see when public companies are dealing with each other, business-to-business contracts, and have a choice of whether they are going to include in their contracts an arbitration clause or a jury waiver clause, would they do so? And we found, I think surprisingly, that 50% of the contracts we reviewed did not have a jury waiver or arbitration clause, meaning that probably still a majority of repeat users of our dispute resolution system are trust in juries to decide disputes with co-equals. Of course, consumer contracts are not included with those filings, those 8K filings. We then went and interviewed general counsel, and we again surprisingly found that a number of them are getting sick and tired of arbitration, where they have to pay 3 judges $750 an hour, where there's no right of appeal, and where they think that the discovery, the length of it, and the expense of it is just as high as it would be in a jury trial. We have surveyed judges around the country of their use of certain innovations. We have conducted tests, as I will explain in a little while, of whether those innovations work, and we're putting on programs like this. This is our 23rd jury improvement lunch around the country. By the end of the fall, we will have conducted 26 or 27 of them. And in some of the cities, we are doing the second, third, fourth one, because what you will get, those lawyers who are here will get a questionnaire this afternoon, a survey, electronically urge you to fill it out, because we asked you to indicate whether you think this is worthwhile, we should do it again, and whether you're willing to be involved in the planning. Because the whole idea of this is to get some local lawyers in every community to say, this is a good idea. It's nice to talk with judges and jurors and other lawyers about actually going to trial in cases. And so, all of these programs are videotaped. The videotapes are put on our website. We have published for 24 months now, each month, a newsletter. You have a couple, the most recent ones is September and October one on the table before you. I urge you. And if you came today, you will be on our mailing list and will receive our newsletter in the future. We have created and maintained a second website called We the People, We the Jury. And this is for people who have served on juries and been discharged, and if they come to this site, they get to this site because the judges give them, we ask judges hand out to their jurors who have been discharged this little card. Every judge has at their table, up top, when they get here at the head table, we'll have a stack of these cards, and we urge them to give it to jurors when they discharge them. And it gives the jurors a place to go to and talk about their experience. We have had hundreds of jurors, and I will say 98% of people who go to the site, to click on that, served jury duty before. 98% of people that go there have had a great experience and rave about the experience. I assume if they didn't, they would never even come to the site. Certainly not complete the questionnaire. But, and we have, and they give us a lot of ideas of things that they didn't like and did like. We also have, if you are currently on a jury, that you click on that scale, it says you shouldn't be here, the judge told you. When you are discharged, come back, because we are interested in you. And on the last one over there, received a jury summons. Those are people we get to by having an active presence on social media, like there we are on social media. We tweet a lot, we use it a lot, we have a lot of followers. And they come here looking mainly, find us, because they're trying to get out of jury duty. And they're looking for, and when they go to that, receive a jury summons, to their great surprise, I'm sure, they find we are playing them video testimonials for people who served before. We go out to the community, videotape a 3-minute thing, and they see a lot of jurors who say, don't throw away your summons, you're about to have the best experience of your life. It's great to work with people. It's great to deliberate, great to see how our justice system and court system works. And hopefully by doing this, we will increase the yield of jury summons, which, as you all know, is woefully bad. You have at your tables a list, 2 charts side by side. What we have tried to do is list the reasons we think jury trials have disappeared, or are disappearing, or declining. And we have divided them into 2 categories. On the left are the ones that we think it's very difficult to do something about. And I now have that up on the screen. And on the right side, we have the reasons that we think we can do something about. I mean, obviously the ones on the left can be done something about, but it requires legislative changes or a change in the composition of the Supreme Court. But on the right are the things that we think can be easily changed. And we urge, we would like you have, on the ones you have, our email address. So we'd like you to look at this chart. If you can think of things we have omitted or think we have mischaracterized them, please let us know. Because it's the projects that we are working on are the ones on the right side of the chart. We have been hearing a lot recently about the importance of judicial independence and how that is assured. It's assured at the federal level by lifetime tenure. But 98% of cases in this country are tried by state court judges who are elected. And no state which elects judges ever gone the other way and relied on having them appointed for life or even long periods of time. They're all subject to recall by election. Americans have always believed that juries are the best way to protect citizens from judges who may not be independent of litigants or may not be independent of the president who appoints them. And now, to get our discussion going, well, this is going to be kind of interactive. I would like our judges who are here, who have kindly volunteered to participate in the program, to come forward. Judge Otero, Judge Schneider, just come forward, and I'll introduce you all as you come forward. Bachner is here. Judge Baffer. Judge Maloney is coming up. Judge Fisher. I have not seen Judge Fitzgerald here.
I don't think so.
Hmm?
I don't think so, but I think he might have been in trial.
Yeah, and I may
can't
have.
tell you it's jury trial.
Yes, we would not want him to. I sent, and now I'm going to try to be the moderator by asking some questions to you. I sent you all yesterday this list that's up on the board. Let me just go down the line and see if Judge Otero, would you add anything to this list? Right? Or what, have we misclassified anything? Anyone has any comments on the list? Anyone got any comments on this list of the reasons? Yes, sir.
I think the list is comprehensive. I went through it twice, and I emphasized the cost of experts. I'm in a civil trial department here in Los Angeles. Last 3 months, I've tried a 5-week asbestos talc case. 2-week went to mistrial because the plaintiff died, and another asbestos talc case. I had a 3-week sexual abuse case. So I read these, and they talk about the decline of the jury. We don't have any decline. We have. I had to ask for 2 days where I could catch up on things after a 5-week.
In your court?
In our court, in the civil court, because we have about 30 judges who are just trial court judges. Then we have about, I don't know, what, 50 IC judges that handle. We have a large number of judges that just try cases, and they're always busy because we have the added burden of many unlawful detainer cases where the lawyers are seeking jury trials now because of Green versus Superior Court that says you can try habitability. So we're getting a lot of those cases.
So Maloney, in your state court here, do you have a central, is it a central docket for the state court? I mean, where
If
you
you're
say
in-
you just try cases, you don't handle discovery disputes, you don't.
Exactly. We have a dual system. We have the 2 judges to my right, Judge Baffer and Judge Bachman, are in individual calendar courts. And they don't handle, for the most part, personal injury cases. They have some, but for the most part, they don't. Those were removed. And those cases are with the trial court. You legal mal, med mal in the trial court, et cetera. The IC courts are different. They can talk about that.
Do y'all try cases?
All the time, which is, I think we talked about this when we were back in New York. California seems to be an exception to those statistics because I'm basically in trial all the time, and at least 2 trials a month between court trials and jury trials.
Why is it so difficult for me to get statistics on state courts? Y'all hiding? No, I say this, I don't say this facetiously, because it's clear to me going around the country that, for example, the federal system clearly has things. It is impossible for me to find out, without a freedom of information request, how much time each of you federal judges stay on the bench actually trying cases. I can find out statistics for the district, the central district, but not on a judge-by-judge basis. Now, is that available? Of course it is, because there's a jury, someone in the clerk's office that pays jurors, that has a record of how many days a jury sat in your court, or your court, or your court. But I can't get that information. Why isn't it? So I asked my research fellows at NYU to try to get me information on state courts in California. Why is it so? Who can I call to verify your claim?
I think you could call any one of these lawyers here.
No. That's the wrong way to do it. Everyone
That's-
thinks they're busy.
That's
Okay?
facetious.
But I mean,
We have,
you know,
right.
well, when this is over, I'm going to be in touch with all 3 of you, and we will see. And if I get statistics that prove you're right and I'm wrong, I'd love to find them, because it will make California quite different than other state courts which we've gone to. But another thing I noticed is, and I think it's related to, so in the few jurisdictions left where there is this kind of centralized docket, where a group of judges only try cases, that's all they do. They don't handle discovery disputes. They don't handle summary judgment motions. When a case is ready for trial, they call up and say, send me another one. Baltimore City is that way, for example. State courts in the city of Baltimore. And that used to be true of courts all over the country, central docket. But with the advent in 1983 of the Rule 16, the federal rules, and pretrial conferences, and managerial judging became in vogue. And the idea was, if a judge lives with a case from beginning to the end, the judge will be able to handle more effectively handle disputes, resolve motions, and the goal seems to be efficiency in disposing of cases, not trying cases. So it does not surprise me that in a regime of individual dockets, Chris, what do you think? I mean, you have an individual docket, right?
We all do, yes. Yes. I don't think there's anything wrong with managerial judging. I think it probably, in a sense, causes the parties to think about their case, settle their case, which I know is not necessarily the goal here, but when you sit with a full docket of more than 300 cases, on the civil side, it's something approaching, I don't know what, Jim, 200 criminal cases at any time, because of our 8 vacancies out of 28 positions. You start wanting to manage cases, you want to be in charge, and you want to be blunt, limit the nonsense of people who, say, oh, I've got a new judge, I can try this idea out again. So I think managerial judging is a good thing, but to diverge from it, on your list, you have discovery rules allow parties to discover the facts without having to go to trial. I need help in understanding what you mean by that.
Well, there is a Yale professor who has said that trials kind of became obsolete when we had the federal rules, the discovery rules. So you used to have to go to trial to learn what the facts were. There weren't a lot of depositions, there weren't a lot. But now, people basically discover all the facts in pre-trial discovery. I mean, I'm not saying that's bad, it's good, okay?
Okay.
But it makes the trial kind of irrelevant. Good lawyers should be able to, this is what mediators tell us all the time. You finished your discovery, you've seen all the documents, good lawyers ought to be able to evaluate the case and settle. So in the olden days, no one had, when I began, it wasn't quite like it is today, that people were felt that you had to overturn every stone in discovery. So you weren't surprised at trial. And if you're not surprised at trial, why have a trial? You know what's going to happen. I mean, that's what I meant.
Okay, and I don't want to monopolize the conversation, but you're saying something very important about experienced lawyers, but because I happen to have known you for some 30 years, I know what you're talking about. You might just tell people how you used to try cases and ask people for the important documents, so that you...
Yeah, I mean, to me, well, yeah, because I would try to get people to say, we will only have 100 exhibits. I lecture, I go around the country lecturing to lawyers, say, you should not, the trial should not, no opening statement should go on for more than 30 minutes. No closing argument should go on for more than an hour. No one should use more than 100 exhibits. Those are certain rules, and you need to be an idiot to use much video testimony. Jurors fall asleep immediately. So, yeah, that's the way I used to do things. But, the law practice has become a big business, as you all know. People make a lot of money charging by the hour. There are things that judges can do to help us, like I urge also judges, get rid of the pretrial order. That is such a make-work project. The have to designate deposition testimony, 98% of which never gets read to the jury. It's a project you assign to young associates, they go designate testimony, and they run up a lot of double hours designating testimony. But we need to think about, so let me ask you this question. I'm curious of what your view is. What is the explanation of the fact that bench trials are declining as fast or faster civil trials than jury trials?
I'm going to yield to my colleague.
Yeah, Judge.
I would think that if you're going to have a trial, you're going to opt for a jury trial. If you're a plaintiff, a jury is likely to award a higher number than a judge would. If you're a defendant, you're going to have to, a plaintiff is going to have to convince in federal court everyone. It has to be unanimous. So there's a dynamic at play that would I think if you're going to have a trial, you're going to both sides would opt for a jury trial, and that's probably one of the reasons.
All right. So, put that. So they're both, why are they both declining? Because people don't like to air their dirty length. The one thing the arbitration is that you can't give us, no, you can't. It's confidentiality. Is that it? That your public disputes resolution is in the public? People want to resolve their disputes confidentially?
I think you hit on it in terms of you've done everything when you prepared for a trial, especially with billable hours in the defense. You have done everything conceivable, and all that's left is the play. And if you have a good actor in the lawyers, they're going to put on the good play because they know the lines. And that's what we have in a very effective trial. You see that. They've got their less than 100 documents. They've got their 30-minute opening, their hour closing. It's a beautiful thing to watch. You don't get it all the time. But I think one of the reasons that doesn't occur more often is because everything is done and they look at it realistically and they say, what's the upside? Especially because the first thing you put on there, the cost of the experts. I think that drives so much of it. You see the huge amount of money that has to be fronted.
But here's my challenge to you is this. I, as a lawyer, don't think the expert expense in a jury trial is any different than it is in a judge trial, bench trial, or in arbitration. You got the same expense, okay? So that can't, we can regret that we have come to the point that all dispute resolution requires experts on either side. And when we go around the country and we do have jurors present, we ask them what effect experts had on them. Usually very little, because both sides have experts. So, but what you know, that seems to me to balance out the difference between arbitration and jury trials, you know, or bench trials. Expert expense is the same. Discovery expense is the same. What I found to my great dismay is judges who are doing bench trials around the country are now allowing some of the things that I don't really, like a motion limine, what does that have, what place does that have in a bench trial? What place does it?
I don't listen to them in bench trials.
What place does summary judgment have, Judge? I mean, you're gonna decide the case. When you decide on summary judgment, you decide after you hear a few witnesses. I don't quite understand why we have made bench trials so, bench trials could be cheaper. But I think when you balance out, so, I mean, when y'all conduct bench trials, is it fair to say that you are, take more liberty with scheduling 2 hours here, and 3 hours there, 4 hours this week, and come back next week? And I mean, it's also fair, I think, to say that when the evidence is over, this is true of arbitration too, I don't get the decision right away. In a jury trial, the fact that he's saying when that verdict is handed back.
The lawyers, though, in most cases, ask to do written briefing in court trials, is my experience. So they don't want me to rule immediately. They want to get that additional time to put everything in writing.
Oh, they want to build more.
Okay, but you ask why.
Let's be fair.
But you ask why. The lawyers are saying that to me. I'm not saying it to them. I'm not inviting it.
No, I understand that. But, so it seems to me, one of the things we gotta do if we're gonna keep public dispute resolution, I've come to this conclusion after doing this for 3 years, only the judges can solve the problem. Lawyers cannot do it. We are, what's good for him is bad for me. It's tit for tat when you're in the heat of battle. It's, you know, you just can't, the bar organizations are too slow in proposing rule changes. Creative judges have got to be the ones that help us here get over this problem. Let's talk about the delay in getting to trial. In your courts, your court, for example, is a jury trial likely to be any longer to get to trial than a judge trial?
I'm a proponent of managerial judging, and so I try to bring a case in as quickly as I can. That's probably about 6 months from the date that the complaint is filed. That's as soon as I can bring it in for a scheduling conference. And my goal is to set a trial 9 months to a year from that date.
Okay.
And to hold the parties to that date to the extent I can.
Well, I mean, I assume you can. You can say, the only way this case is going to be moved is someone dies. Like I die, or you die.
Or someone becomes sick.
Yes, yeah.
Or
I mean,
somebody-
there's always good reasons.
But it seems to me we've let the system become, in general, the law practice. I know that nothing is set on my calendar, nothing I have said is ever going when it's supposed to go. Justice Gorsuch made a speech right before he went on the court that said 90% of all trial settings in this country are continued. That is a hell of an indictment to the way we are going about our business. I mean, why don't we tell lawyers, you got 4 months to get this case ready for trial, and we're going to trial 6 months out, and if that means you can only work on 3 cases rather than 30 cases at a time, you better only work on 3 cases at a time.
I'm going to deny all future requests for continuances on your say-so.
No.
It's the lawyers who come in. I mean, I never continue them because I'm not, or almost never, unless I have a criminal trial that I have to deal with. But it's the lawyers who come in, they ask for an extraordinary amount of time to begin with. I've given up trying to cut it down because no matter what I set it for, they always ask for more time because somebody hasn't cooperated or they're having discovery disputes or somebody died or is sick or they have another trial. So yes, I can say no. I guess I'm too much of a softie.
Yeah, it's not that you're a softie, it's a habit that our
Not too many people have said I'm a softie.
judges, a habit we've fallen into. We're all guilty of it. We're guilty of it because, you know, I have got to be civil to the person on the other side. If I know this deadline is not a real deadline, if I know the case is theoretically set for trial on November 1st, but that ain't ever gonna happen. So can I be kind of a mean person and say, no, I'm not gonna give you we're not gonna move the deposition. We're not gonna give you more time to produce documents. And, you know, so the judges preached us, and rightfully so, that we should be more civil to each other. And if you're gonna be civil, but you live in a world where no deadlines are real, where they all end up being moved, 90% of them end up being moved. And judges, all I have to do is get your two people on the opposite side to agree. We go to the judge and say, Judge, we would like to move it. I understand why judges are reluctant to say, no, we're not gonna move it. Because both lawyers agree with it. But my only point, so I'm not gonna preach anymore, I do think it's part of the problem that we are trying to deal with. So let me ask you this. How many, so in state court, do any of you set time limits for trials?
As far as the duration of trial.
For the duration of trials?
So we, at our initial judgment with an independent calendar court downtown, so it's an unlimited jurisdiction civil calendar. There were 41 of us downtown. We're assigned a docket. The central civil average downtown, again, not PI cases, not limited, it's exceeding 500. It's about 510. We're getting on average 50 new cases a month. That's a lot. So at the initial case management conference, I'm sure most of us asked, because you have the case management conference questionnaire asked for the time estimate for trial. Lawyers are supposed to meet and confer before the initial case management conference, so usually they're on board. I mean, one side might say 15-day jury trial, the other thing is 3, and we'll have a discussion. But, you know, I'll set a realistic deadline based on my experience of it. You know, it's a single plaintiff case versus 5 plaintiffs, and how many defendants, and how long should it take to try this case. You know, a lemon law case takes a certain amount of time. You know, a FEHA, labor and employment and wrongful termination case takes a certain amount of time. So I give a time estimate that seems appropriate based on the number of jury trials. I mean, I've presided over more than 70 civil jury trials downtown in the last 5 or 6 years or so. So I have a good idea how long a trial is going to take. I might build in an extra day or so.
How about you,
Time
Judge?
the trial set, I would give that.
Do you set time limits on trial?
I do, and one of the things is Bruce Boylett, a member of the Consumer Attorneys, well known, he and a number of other lawyers came to our presiding judge, Dan Buckley, and said that they wanted to have a conference, and our ceremonial court is huge. It was full of lawyers from the plaintiff and defense bar and judges. And basically what they said is, we want you judges to take over. We want you to set time limits. So we don't want a 5-week trial. We want to do this in 10 days if we can. Talk to us and get us committed to how much time, and then hold us to it. And if we agree to be held to it, and these were prominent plaintiff and defense lawyers, hold us to it. We don't have an issue with it. I haven't gone to a chess clock, but I do it manually, where I keep track. And I've done these expedited jury trials where you do them in a day or two, and you give them 5 hours, and you lose it, voir dire and everything else. You get through those trials. I can do it in the larger cases too. And the lawyers don't seem to mind if I say to them, how much time do you need? And then they'll say, I need 3 hours for this witness. This is in the pretrial. And we'll break it down. What exactly? Give me an offer of proof you need 3 hours for this witness. I can see 15 minutes. I was only a lawyer 34 years, but I tried. I tried a few cases, and you don't need 3 hours. So we break it down. We get it down. We get it down to a certain amount of hours. Okay, you've got 12 hours. You've got, and I know they do that in federal court. And you've got whatever it is.
So this is becoming a time of going around the country and talking. I've probably talked to more people who have been on jury duty than any other lawyer in America. The most repeated criticism of jury service in trials is repetition. They all think, if we had jurors here today, you would get that from them. And they would also say, we could have decided the case 3 days before we were allowed final argument. And why do the lawyers do themselves over and over and over again? So we are preaching setting time limits, and every lawyer that I have talked to who's ever been in a time limited trial thinks it was a better trial because they were forced to plan like a Broadway musical. You have to plan it to be a 2-hour performance. It's not, people do not have the attention span. So, but lawyers, and the only complaint I've ever heard from lawyers, plaintiffs' lawyers sometimes say, the burden of proof is on us, and it's unfair to divide the time equally. But there's a recent decision out of the Colorado Supreme Court that says, presumptively, that's fair, it's divided equally between the sides, even though the burden of proof is on the plaintiff. I thought, and federal judges are doing it more, but and some of you may be familiar with the fact that on Friday, the Ninth Circuit, in a case called Skidmore versus Led Zeppelin, said this: strict time limits are generally disfavored at trial, citing the 1994 very careful decision in Montauk Corporation versus Typeface Corporation. I haven't read it, but that's a long time ago. Given the complex nature of this case, we are troubled by the strict imposition of time limits and the relative inflexibility of the district court once Skidmore ran out of time. On remand, if the district court again imposes time limits for the retrial, it should ensure that each side has adequate time to present its witnesses and arguments. Now, I don't think that should discourage any of us from time limiting trials, because it was a case, because it was a case, frankly, where the lawyer who was representing, I think, the plaintiff, who was clearly not experienced and wasted a lot of time and didn't have time left to cross-examine the other side's experts. So, you know, a good lawyer would not have let that happen to him. Every trial I've been in was time limited, no matter how complex. Both sides have given time back. None of us have got to the position where, and we all finish a day early. And none of us play video depositions. We all managed to find live witnesses who can tell the story. Some judges around the country, to make it easier for the jurors on this timing, are using an alternative schedule for jury trials. Have any of you experimented with 8 a.m. to?
I do 8 to 2.
8 to 2.
I do 8:30 to 11 o'clock, so they can get an early lunch and beat the traffic, and then we go from 1 o'clock to 4.
Yes, sir?
I've done it, we have union issues.
Yes.
And I've been told by those in authority I'm not to discuss those union issues, because they're always in negotiations. So, but we do have union issues. But what I do is I talk about child care issues or adult care issues, and I'll say to the jury, we want to keep this time. And every day I talk to them, we're on schedule or not on schedule, or we're ahead of schedule. But I look at it and I say, can we start at 8:30? 8 is pretty tough because of child care issues. I have problems there. But 8:30 they can do it, and then we'll go till 1 o'clock. Now, that's not quite 5 hours. We get 5 hours and 15 minutes in our regular trials, 9 o'clock to noon, 1:30 to 4:30. That's 5.5. You lose a little bit of time, the jurors being late from the restroom, et cetera. But you get about 5 hours and 15 minutes. If I can get 4.5 with that early schedule, then the lawyers have time in the afternoon to get prepared for the next day. And I think it works better. I like it. I wouldn't mind it more often, but I do have that union issue I have to face.
Okay, but
Because they want that hour and a half for lunch.
well, all right, another thing the jurors always complain about, I'm kind of the proxy for the juror. There are probably some of your jurors, I don't know, because I haven't been before. I know what a complaint is, that they waste a lot of time sitting in the jury room together, okay, where the judge says, I've got important work to do, or whatever it is. No one believes that, okay? But jurors are real smart. And, you know, I know the judges try to sugarcoat that by saying, we're making this trial shorter and better for you, So please forgive us if we make you sit in the jury room for 2 hours.
We're not allowed to cite because the defense lawyer didn't show up on time, or the plaintiff's lawyer is making some motion, so we have to say we're doing it for you.
Right. Or counsel blindsided you through the
Well-
stack of filings every day that could have been handled at the final status
Right?
conference. But we're
So
seeing,
tell
we're
me-
seeing that a lot.
Tell me,
Morning stack.
tell me, I think you have power as a federal judge.
I do. The lawyers show up at
Just say the judge-
7:45 and that's it. They got 15 minutes. If they haven't talked to me about it then, they're not holding up the jury.
And can you tell the jury that if you're sitting back there beyond the 15-minute time, it's because one of the lawyers didn't show up? And I'm going to
Then
identify.
tell me which
I'm gonna
panel
ask-
of the Ninth Circuit
and I'm-
will get the appeal and I'll tell you the answer.
Well, the Ninth Circuit will get it, but they will say it's harmless error.
That doesn't help very much.
So, you know.
Because
should've
once they
done it.
say it's an error, the poor next judge has got to figure out whether to make
I guess
that
that's
error.
right. But I mean, we have this, but that's a problem. Does anyone forbid sidebars?
Yes.
Just forbid
Pretty
it.
much, unless, occasionally, maybe one per trial if it's a true emergency. If someone has asked a question that's just totally off limits, and it's going to lead to a mistrial.
I tell jurors, at the beginning of the case, there'll be no sidebars, but if counsel has a point to make, I'll entertain those discussions at a later time when it's not inconvenience to them.
So every time I go out and do one of these, I have to kind of look at, I'm pretty familiar with federal law, but I have to learn a little more about state law every time. One of the things that some jurors have suggested of this problem of wasted time sitting waiting for something to happen back in the jury room is that the judge has given them the standard California instruction that you are not to discuss the case, the evidence with anyone until final deliberation. I don't think in California that the iteration is being used in some states, like Colorado, every state court. Arizona is where I'm going there. Tucson of Art was invented there, of allowing the juror, in federal courts I'm sure you can do it, of allowing the jury in a civil case, not a criminal case, but a civil case, to discuss the evidence when they're all together in the jury room. Before, as long as they do not decide the case. There was empirical research done in the state courts in Arizona, the jury trials.
I do too.
Huh?
I told them not to.
We have, the standard Ninth Circuit instruction is don't talk to one another about the case until you've heard all the evidence.
It may be the standard instruction, but I haven't seen anything in the federal system that would say that that's reversible error or even error in a civil case.
It may be harmless error, but the problem, I think, from my point of view, is that you don't want them discussing the evidence when they've heard only one side of the story, or a part of the story, or someone whose testimony is suspect or whatever.
Suppose I could present you with empirical evidence, satisfactory evidence, that jurors will listen to your instruction. The instruction given in the courts that allow them to talk about the evidence is, you can talk about things like what the witness said, because some of you may not have heard it, or have a disagreement over what the witness said. You can even talk about what a particular witness was believable or not. What I don't want you to take any votes. I don't want you to talk any conversation about who should win and who should lose. But if you have particular questions, did you hear that witness say anything about it? And most of the questions that people are discussing is what a person said or meant by what they said. And I mean, the jury consultants who have done the empirical research in this area assure us that the jurors, and when we talk to the jurors, they say they follow that instruction. They talk, but you know, and there wasn't that much time back in the jury because they all have to be together. So I'm just suggesting that's a hard one to sell, for sure. But that would be satisfy some of the downtime where they can't even talk about it. How about the subject of jurors asking questions?
Well, I allow it, and it's standard practice, but it's up to every judge.
Yeah, and I allow it.
I allow it too.
Yeah,
Okay, there's,
in written form.
in
Written
report,
questions.
there's an innovation that Israel wants. Every lawyer has been through it, thinks it's good. There are just a few holdouts on benches around the country against that innovation.
If I have an engineer on my jury, I might not tell them.
The objection I have is that it slows down the trial, which I don't think it does.
I don't think it slows down the
I don't
trial at all.
think
They write the note, they hand it, I look at it, my clerk hands it to the lawyers to look at, and
Yes.
it doesn't slow it down.
The other objection I hear is from judges, is that it tells the lawyer who's winning, it tells them, you know, where the jury is. Well, I think that's a great thing. I mean, maybe they wouldn't repeat themselves so much.
Maybe the case would settle and
Maybe
that's
the
right.
case would
Maybe
settle,
it would
or
settle.
maybe they could figure out what the jury
What
really
really
wants.
needs to hear.
Yeah,
Mediation. It's one of the things that I list up here. Let me tell you where I come out on mediation, and I would like to discuss it. I think it's perfectly reasonable to make me spend a day in a conference room with my client talking about the merits of their case and analyzing it, because I might not do it otherwise before I go to trial. What I don't think is fair is to make me go to mediation before you have ruled on dispositive motions and before I have a definite trial setting. Because in either case, I'm forced to settle, not because, you know, in the one case, I don't know whether the judge can come out and rule law, why should I have to settle until the judge does her or his work? And without a trial setting, I mean, you go back there, I've many times gone back there and said to the client, we don't even know whether Judge Snyder will be on the bench when this case is set for trial. We don't know when it will be set for trial. We've already been through it with the judge, and it got moved. And so, you know, you want closure on this? Let's say. So would you be willing, Judge, to agree to proceed to agree? Yes, they're forced to go to mediation, but at the time they were forced to go to mediation, you have resolved the dispositive motions, and you have given them a trial setting at a definite date.
I do that.
You do
So
it.
when they come in for the case management conference that Elizabeth mentioned earlier, which is about 4 months after their complaint is filed, I give them a trial date, I give them a final status conference date, and I give them a post-mediation status conference date. I don't give them a summary judgment date, because I don't know if they're gonna file one. If they come in and the summary judgment has to be heard more than 30 days before the trial for the California rules, if they come in and they say, Judge, we'd like to mediate after, we've reserved a summary judgment on blah, blah date, and we would like to move the mediation till after then, I say, fine. But I give them all those, I give them the dates up front, and the mediation date is about 3 months before the trial.
That's fair. You do that too?
More or less the same, right? I don't order the parties to go, I say you should go. I ask the parties, when do you think you'll be mediating? There are cases where they've mediated before the initial case management conference. So, you know, I'm setting the trial out a year in October, when do you think you're gonna go? And so, same thing, I'll set the post-mediation about 90 days before trial. I don't order parties to go, and certainly if they want to wait until the MSJ or MSA is heard, I'll certainly let them do that.
I set the dates.
Can you do the same
Do
thing?
the same thing.
I get my rulings on the dispositive motions before you make me go mediate. The great. I don't know what to do about the mediators, almost always former judges, who look me and my client in the eye at mediation and says, you don't want to go to a trial because you don't know, relying on a jury is like going to Las Vegas and playing roulette. You don't know what they're going to do. You better go settle this case. I think that's a form of treason. I mean, if we all know, I mean, that's, the jury consultants who are present will tell you that they have built a multi-million-dollar industry doing mock trials because they are so predictive of what the real outcome is going to be. So we kind of know what's going to happen, and the judges kind of know too. So why, I don't know how to stop them from making this argument that jury trials are like going to Las Vegas.
Well, I don't know how to stop it either, but I'd be curious of what everyone else thinks. But I find that when the lawyers on both sides are very good and can evaluate the case and know what's going to happen, there's a good likelihood that the case will settle without much intervention from me or a mediator. On the other hand, when there's an uneven match, when you have someone who has a pie-in-the-sky view and you believe that that person is going to fall flat on his face, that's the time to give that speech, that a jury can do anything.
Yeah. You don't believe that they will do anything.
I don't, I have complete
You have
faith in
complete
juries.
faith.
I have complete faith in juries, but, you know, there have been cases where I have almost granted summary judgment and a little light went off and said, you know, better to do a Rule 50 motion. And then the case is tried, and I see evidence that's very different than what's presented in the
So-
summary judgment motion.
One of the things I'm hearing from judges around the country is that, you know what, the lawyers don't try cases. I can't get lawyers to come in and be willing to try cases. They are either too risk adverse, or they haven't done it before, or they are, you know, from big firms which do not have, they're litigators, discovery lawyers, and not trial lawyers, and they get uncomfortable when trial approaches. And so it seems to me that, and that's the kind of lawyer you're talking about, who's, you know, a green lawyer, maybe, or a young lawyer, or an experienced lawyer.
Or just a bad word.
The bad ones don't.
There are some of those,
bad,
but
though.
it's clear to me that one of the things we have to do to keep trials alive is we have to keep young lawyers trained to try cases, which becomes harder and harder to do in law firms like mine, where there just aren't that many trials. You can promise you're going to give them trial experience, but delivering is a different thing. So a couple of things that have occurred to me, but again, we need the judicial bench on this. It's gotten very popular in the country, and we're preaching to everyone. Please enact a young lawyer rule. By a young lawyer rule, I mean a lawyer, you can define the young lawyer can be less than 5 years of experience, or less than 35 years of age, or however you want to define it. You have to define it so someone like me doesn't come in and take advantage of it. But it's basically that if the lawyers will tell you that a young lawyer is going to argue a motion, they will be guaranteed a hearing, because you don't want to hear Sussman come in again. He's been here before, I know what he's going to do, and all these trick stuff. But a young lawyer, yes, you'll get a hearing. So are y'all have rules like that? Are you willing to do it?
I have it in my standing order encouraging law firms to bring in a young associate, 5 years or less, who would be able to argue. I've seen it occurring in my patent cases. So in my claim construction, the firms are bringing in a lawyer, young lawyer, to argue one of the terms or a couple of the terms. And it's working in the patent litigation.
Right. You know, I think the judges could do the same thing with trials. I mean, you basically have control of your document. You basically tell lawyers, if a young lawyer will serve as lead counsel, defined as makes an opening statement as part of the closing argument, and will cross-examine some key witnesses, then I will give you a preferential process. Now, all this, I mean, what we have learned around the country is that it has the effect of putting more female lawyers on their feet in court, because they're the ones who are usually writing. I mean, in my firm, we kind of have a rule: if you write it, you speak it. So if we had that rule, only females in our firm would probably go. I mean, it would be heavily weighted towards women lawyers making more arguments. Another thing that occurred to me, and I got this idea last week. I was with a very good lawyer from Dallas, Dick Sales, who was named Dallas Trial Lawyer of the Year. I'm on panels now of old timers, two old guys who've done it a long time here, and ask about our trades. He pointed out something that was very important. 5 years ago or 10 years ago, it was very common for lawyers like him and me to be the onus on our feet at court. In other words, they were helpers, but they weren't allowed to be. There was a thought process that if you had more than 2 lawyers at counsel table, you would be viewed in some, you've gotten a lot of money, you've got assets, but judges are telling us now, and jurors are telling us, that it doesn't hurt to have 4 or 5 lawyers at counsel table doing stand-up things in court. I mean, you've got to make it balanced. You can't have them there as just show lawyers. But I think if judges felt that way and communicated to the bar in that way, that, and maybe even said something to the jury at the beginning of the case, you're going to see a lot of lawyers on both sides of this case. I'd encourage you to bring as many people from the firm as you got, because I guarantee you they all got armies working in some hotel room somewhere or trial office somewhere, getting ready. I'd encourage you to bring as many as possible here. And so hopefully, and that's the only way we're training young lawyers, and give that little speech to juries. I think it would help get rid of this kind of old-timer view that real trial lawyers are long guns. You don't rely on, you don't need help. And the jurors, by the way, have all told us they love to see different people do stand-up things. But you can help us there too. Okay, there's an innovation that I'd like to ask you about. We have had some judges around the country now require lawyers to make a complete opening statement before voir dire begins. And I mean, an opening statement to the entire 60 people or 70 people on the area. Judge Martin from Kansas is one of them. He just emailed me. He did it he's doing it as in a case yesterday, it began yesterday. And we have been in his courtroom and interviewed jurors who are not chosen and lawyers. Everyone seems to love it. They love it because you're going to have to make the opening statements sooner or later. It's either made Monday before jury selection begins, or Tuesday morning after you have 12 of the box, or however many you put in the box. You get a better voir dire because you don't have to make it. So I noticed that almost all the rules now, state for sure, and maybe federal, say a good practice is to allow the lawyers to make a brief opening statement before questioning of the narrative begins. And I had an argument. I asked my assistant the other day, does that exclude using a full opening statement? So no, they don't think it does. It was just, you could do a full opening statement. It's not repeated again after jury is selected. It's done once and only once. You get more candid answers to questions. And when we interviewed jurors who had been discharged after listening to that, they liked it. They thought it was a great experience. They were more interested in the court. They thought they had accomplished something by coming down. So has anyone done that?
I've done a mini opening statement so that it's condensed.
Right.
And the purpose there is to entice the jury. If the case appears to be boring, a boring civil case, it entices the jury to want to participate.
So would you be willing to go the step further and say, that's your only opening statement?
Why not?
Why not?
With good work.
Chris?
I've never done it, but it intrigues me. I would consider it.
I do a mini opening. I offer a mini opening. Oftentimes lawyers say they don't want to do it unless they both want to do it. I don't make them, but I guess depending on how long they plan on having their opening statement, I would let them do it for the entire case.
We're required under Rule 222.5 of our Code of Civil Procedure to allow a mini opening statement. I like them as a trial judge because it gets the jury interested. They know it's not a contract or a real dispute or something. They know what it's about. And so they answer those questions not in a vacuum. They answer those questions based upon what the lawyers told them. I mean, they could probably reach a mini verdict at that point just based on the mini opening statements. And so I find it very effective.
That's the one
But
object.
to answer your question, I've never done it where I would not allow a full opening statement, because usually they say, give me 3 minutes, Judge. And I said, yeah, after about 3 minutes, you're gonna start to argue. So I said, yeah, about 3, and then 3 minutes is about fine, they might go 4 minutes, but it's about right in that
Well,
range.
think about, I'm not gonna persuade you now, but think about talking to some judges who try with a complete opening statement and not, I mean, the lawyer doesn't have to repeat himself, he's already done it. What's wrong with that? If the jurors like it and the lawyers like it, and they think they get a better answers on what they are, more complete and full answers than they do otherwise. By the way, federal court, they took away our right to voir dire jury, lawyers' rights. I don't remember, I haven't done the research to figure out why they did that. Apparently we were abusing it real bad.
Too much time
I
and
mean,
silly questions.
Judge Jamel was arguing the entire case, you would win the case, you know, it'd be all over by the time the jury was selected, so we lost it, but now we are gaining it back. I'd say 50% of the federal courts in the country are allowing lawyers to do why do, you know, 30 minutes, questions, not,
5 minutes.
well, no, that's hardly allowed.
And I tell them if they only ask good questions, they can keep on going until they
Okay.
get one I don't approve of.
All right. How about you?
I do all the questioning.
You do all the questions. Judge Schneider?
I do all the basic questioning, but I tell the lawyers that if they want to follow up with a particular juror, come to sidebar. That is the only time we do sidebars. I invite the juror over because oftentimes, particularly in a criminal case, the information is too sensitive and the person really doesn't want to discuss the matter in public. And I make it clear that we want to know all the facts. I find that that's the best way to get them.
In the state court, lawyers are allowed.
And we cannot
You can't
set
stop.
unreasonable or arbitrary time limits. And there are factors, the consumer attorneys were involved in Sacramento getting this changed. And there are factors, there are like 4 or 5 factors we have to consider in terms of how much time. So if you just say 20 minutes, there's a case that's reversed that said that's unreasonable and arbitrary. You know, my rule is 20 minutes, you know, my way or the highway. Court said you can't do it.
Some of the federal judges that are now allowing the lawyers back in the tent have told me that lawyers look at them and say, no, Judge, you do it, it's fine. I don't want to do it. You're doing a great job.
Oftentimes they'll ask no questions or just one or two.
So I wonder whether that's because you are doing a great job or because they have no experience.
Because I'm doing a great job.
I mean, but it is a fact, for example, that there's very little training about lawyers to conduct. You can get all these CLE programs, PLI programs on jury trials. They talk about how to cross-examine a witness, how to make a mistake, final statement, et cetera, et cetera. Never have a program on here.
What I was going to say though, of course, we invite, and I think I'm accurate, the lawyers to submit written proposed voir dire so that you can go over the subject matter. I mean, the objection that I have to lawyers conducting voir dire is that if you have Joe Jamel in the courtroom, then you've got someone who is basically arguing the case through the questions.
True. I mean, that's true.
Yeah.
But I think most lawyers now have been trained not to argue the case. I mean, the jury consultants tell us that they don't listen to you, they don't trust you at that time, so you're much better just to answer all the questions. But some of the questions that I've heard asked, so tell me whether this is objective. I either ask myself or ask you to ask, which person, living or dead, would you like to have dinner with most? It turns out that the jury consultant, who's the jury consultant here? We have, that's a hell of a question. to find out what kind of jury you get. Would you allow that question to be asked?
Well, what
See?
they could-
The question that I think is the most important, that question, they're not gonna let, why not?
Because that's not the purpose of the here.
And I let them. Let's say that they have 45 minutes, you can use your 45 minutes to ask, I changed my mind, I used to not let it. But no, if you can use your 45 minutes however you want, unless it's an improper, literally an improper question, if they're misstating the law or arguing the law. But if they want to ask that question, go for
Now,
it.
so let me, the judges who think it's improper, suppose let's talk about the use of a written questionnaire to the jury that they fill out in advance with more tailored to the specific case, which I understand is fairly common in state court in California. I mean, I've seen rules that permit that. How about federal court? Do you allow lawyers, if they agree,
Yes.
to submit a questionnaire?
For the jurors to write the answer?
Yeah, I mean,
I've
Yeah,
done it
yeah.
once on state court in a high-profile misdemeanor case, and once on federal court in a high-profile felony case.
So
Sort of takes a
you would-
lot of time. In the misdemeanor case, I don't think it was helpful. In the felony trial case, it probably was. It made things more efficient, made the eventual selection.
but suppose two lawyers come in. We say, we have a questionnaire, because I usually can get the other lawyer to read this. We have a questionnaire, we agreed on what the question is. It's no more than 2 pages. Or maybe 1 page. Everything can be done on 1 page. But there are questions on it, and we've agreed to it, like, who would you most like to have dinner with? Where do you get your news? Where do you usually get your news is another question that we would put on there. And we also come to you and ask, Judge, will you submit this to the potential jurors in advance of our coming down to the courthouse? So we can have time to study it and you will not do that.
I would do it, but I'll let you get through.
Judge
it.
Otero?
Where in
you do it?
advance of coming to the courthouse comes from, because until they come to the courthouse and I call down and say, send me my jurors, they're there, and I don't know which ones are coming up to me, so we would have to.
So,
It'll depend on the questions, but I'm inclined not to allow those types of questions.
well, because you know the two lawyers are going to go on the web, on the internet, and Google the jurors, and go to social media, and try to find out something about me. What's the problem with that?
I don't want to take the time. I just want to get the trial started, get it over with.
So,
I don't know how much time, it takes. I mean, usually, I know who's gonna be sent to me. Well, I don't really know who's gonna be sent to me, but they can ask the people in the jury assembly room to have them answer questions up there, which you can do in a criminal trial, in a non-criminal trial. I should say. In a criminal trial, defendants have a right to be present. I'm in favor of it. What I do like about it is that I think people are more candid on a form than they might be speaking in an open courtroom. And the questions like, what do you read? What magazines do you read? Well, some people, have very limited reading skills, and they really don't want to say in front of other prospective jurors, I read the National Enquirer or something, or I don't read anything.
so it occurred to me, we have a judicial advisor, actually. He has a piece in the October, the judge from, senior federal judge in
Lassen.
Seattle. Lassen.
Robert Lassen.
He has a piece on Seattle, the federal court, and the state court in Washington have been very proactive in adopting rules to give teeth to Batson. So they have a special rule that if certain things you do or ask are presumptively a violation of Batson. So, and so to me, and very interested, all the jury consultants are interested in the subject of implicit bias. We all have bias. And they give you this little test to show you how biased you are, because you have to answer questions. And it's clear that you rely on your biases, you rely on your stereotype when you have to make a quick decision. When the judge says, now that I finished voir dire the jury, you have 20 minutes or 10 minutes or 15 minutes to go into the jury room and exercise your strikes. The temptation to a lawyer is to rely on certain stereotypes. And if you had more time to think about it and discuss it, maybe we wouldn't be having to rely so much on our implicit biases about what we think about certain people. We stereotype people. So maybe one of the solutions is to give people more time to think about how they're going to exercise their strike. And since, you can do anything today by internet, by email. Why wouldn't we let jurors fill out a questionnaire over the net, over the web, send it in, decide on our strikes for cause. If someone has a hardship, figure out what the hardship is. You've already set the trial. You know when it's going to take place. And by the time they get down there, I would be willing, as a lawyer, if I had that information, to exercise my peremptories without seeing people or questioning. I could do enough, find out enough by what is ethically permissible research on the web with a more fulsome questionnaire to exercise my 3 peremptory and any challenges I have for cause. So given the fact that why isn't the justice system going to something where people vote, they buy cars, they buy houses, they transfer huge sums of money using the internet? Why don't we let jurors, one of the things that people hate is voir dire. They hate it. They hate the wasted time coming down there and not being selected. They hate the time they spend in the jury assembly room. Why can't we as a profession be more creative with how we pick these people? Any thoughts about what we could do to improve that? Judge Maloney?
I'll just say first, I've got it changed on the questionnaires. I have lawyers that have asked, I've used a number of questionnaires, dozens, and I'm coming around to not wanting to use them as often, and I'm forcing the lawyers to shorten the questionnaires. Our rules, again, under this Code of Civil Procedure, allow the lawyers to request a questionnaire, and we can't unreasonably deny their request, as you said. But I'm finding that it doesn't, in some ways, shorten the process. It lengthens the process to some degree, and that's because you don't always get the lawyers that are quality lawyers that realize all that information is already there, don't repeat it. They want to go up and repeat it. So with the internet, the lawyers know how people post on Facebook, so they're going to know what their privacy issues are, and they know that you can't go in and use somebody else's to get access to theirs. That would be an ethical violation. So part of it is a lack of knowledge in terms of how far you can go, what you can do with yours, how you use social media.
We're a little over the time limit. Does anyone here have any questions for the members of the panel on anything? Well, if not, I want to thank them for coming and letting me ask you maybe provocative questions. Maybe, in any event, we need to keep the discussion going, because by keeping the discussion going, we will keep trials alive. And the one thing I will say and close, Judge Fisher, to you, the people who adopted the Seventh Amendment understood that jury trial would take more time, be more expensive, be more susceptible to eloquent advocacy by lawyers like me, even be better for the little guy, see what the big guy. That's why they put it in the Seventh Amendment. The historical record on that is clear. So I understand this idea of it's going to take too much time. It's going to slow things down. But I think we need to reevaluate maybe that, because there are goals of our judicial system. They go beyond getting something done quickly. Thank you very much for coming.